she devotes her legal practice to helping businesses comply with the law by bringing a unique blend of expertise and personal experience to her practice. Prior to her legal career, Lauren spent 15 years in human resources management and obtained a master's degree in industrial organizational psychology. This background provides her with a deep understanding of human behavior and organizational dynamics. In her practice, Lauren specializes in employment litigation, workplace investigations, leave laws, management training, wage and hour laws, government audits, and business immigration compliance. Certified as a senior professional in human resources and a senior certified professional, Lauren is committed to excellence in her field. Outside of work, she is a devoted mother of 2 competitive lacrosse players.
Correct.
An avid gardener and an active board member of the leadership. Welcome, Lauren.
Thank you very much. Thank you, everyone. For those of you that saw that it was me that was presenting and you still showed up, thank you. Appreciate that. So today's session, we're going to talk about Proposition A and the minimum wage and sick leave law changes. The one thing I want to say before we jump in today is I did not write this law, okay? I did not write this law, and I can tell you where all the holes are in this law, and there are going to be things that you're going to have questions to that we do not yet have the answer to. But I'm going to fill in the gaps where I can, and where I don't have the answer, I will tell you we are going to have to get clarification on those points. Like Jacob kindly read my lengthy bio, just a little bit about our law firm if you don't know. Fisher Phillips is a international law firm. We have about 650 attorneys across the country. And if that surprises any of you that we keep 650 lawyers busy just in employment law, it shouldn't. We're very busy. You can imagine we touch anything and everything that relates to the employment relationship. And all we do all day is represent businesses when they are accused of wrongdoing, or sometimes they do wrong, and I have to get them out of trouble. But what I enjoy most about my practice is the proactive part of this type of work, which is how do we get ahead of these things and how do we prepare ourselves so that we comply from the very beginning. So one of the things that my firm is very well known for is that we provide a plethora of free resources to the public and to our clients. And so I will encourage you, these are just some snips from our firm's website about some resources that are available. If you are interested in a summary about Proposition A, I published an article, what was the date of that? 10/24. I think that Matt sent it out to the chamber members as well. But if you want to read more and have more of a summary of the topic of what we're talking about, I did publish an article. It's there in the center of the page. Something else that I just want to provide as a resource to each of you. We have all heard the news, and we have all heard what is going on with the current administration. My phone has been blowing up regarding ICE raids. If that is something that concerns your business, which I would tell you, you should all be prepared and have a prepared readiness plan. A good place for you to start, our firm has published a employer ICE raid preparedness action plan checklist that will walk you through all of the things you should be considering and how do you prepare your business if ICE shows up on site, okay? That is available on our firm website for free. You don't have to contact me to get that, but if you can't find it, just let me know and I am happy to send it to you, okay? You know, this is awkward for people that just slip in. It's like a comedy club. Now I have to pick on you. Have to call you out. And Rick, downstairs they can just sneak in and out the back.
Yeah, you know? This is much more entertaining.
Okay. All right, so let's jump into what we are here to talk about today. So Proposition A was on the November 5th ballot, and it was approved by Missouri voters by about 60% of the vote. So what that did is it amended or changed state law. It was not a constitutional amendment. So that is important for purposes of how the law changed and how the law can be challenged, because it is a state law, not a constitutional issue. So what it did was it amended Section 290.504 of the revised Missouri statutes. That is the portion about minimum wage. And then it also added and enacted 15 new sections to be known as 290.600 to 290.642. Now, this is where someone like Rick would call me out and say, apparently lawyers can't do math because 600 to 642 is much greater than 15. So I got ahead of that one, got ahead of that lawyer joke. But anytime that there is a new enactment, there are always placeholders for other sections to be added at a later time. All right. Now you need to be aware of that this law has been challenged. So on December 6th, there was a lawsuit filed challenging these election results. Before any of you automatically just stand up and walk out, because if it's pending, why do I need to hear about this now? I will tell you that in all the smart lawyers that are in my office, we have all evaluated, put our heads together, and I think that it is highly unlikely that this challenge will be successful. Now that's just some lawyer predictions, but there are a few reasons of why. Additionally, did any of you sit in on the Missouri Chamber's presentation on this topic last week?
I did one, but not last week.
Okay, I don't know if it was the same or not. But they did a presentation, similar topics, talked a little bit more about the legal challenges because the Missouri Chamber has taken a stake in that legal challenge to this law. My law firm, the Missouri Chamber, any law firm that I have heard from has the exact same approach, which is you must continue to prepare for the law change. You cannot bank on the fact that it may get pushed, it may be successful for a legal challenge. We have to proactively prepare regardless of this legal action. So the lawsuit that was filed that is currently pending, it was filed and it's pending with the Missouri Supreme Court. It's already been amended once and they've dropped one of the challenge claims, which was the equal protection claim. So the 4 points that they are challenging the law, I have them here on the slide. And also, if you would like copies of these slides, I will send them out afterward. So you don't have to jot all of this down. So that current legal challenge has oral arguments set for March 12th, in which the Missouri Supreme Court will hear arguments on both sides. The Missouri Chamber predicts that they will have results from the oral arguments in the early part of April, mid part of April. If they're able to get a result that quickly, I would be surprised, but hopefully they are moving quickly because there is an April 15th deadline that you need to be aware of. So, if there is also a House Bill 567, that was filed as kind of a placeholder, should this legal challenge with the Missouri Supreme Court be unsuccessful, the House bill seeks to delay the implementation of the paid sick leave portion of Proposition A until January 1st of 2026. So it's coming probably one way or another. So just pay attention today. Think about the action items that you need to prepare or modifications you need to make in your workplace, regardless of these legal challenges. Another thing, I did publish an article about the about the new law. If you sign up for our Missouri legal alerts on our firm website, anytime I publish something like this, you're going to get a notification that says, hey, this law has been stayed, or this law is pushed to January 1st. That's a quick way for you to stay up to date on where this law stands. Okay? And if you have questions on how to do that, just let me know. So Proposition A, after it was passed and after the lawsuit was filed, I just went through some various news articles and picked little snips of everybody's perspective on this. What we have to remember in this room, and regardless of how you voted in November, 60% of the Missouri population approved this. So if you are a business owner that doesn't like this law, I didn't write it. I said that this is the second time I've said that. And the other thing to keep in mind is that 60% of the Missouri voters did like it. So just keep that in mind as we talk through. There's always going to be polarizing views. And some folks say, you know, even challenging the lawsuit is un-American. So wherever you stand on that, we're here to just learn about the law and what you need to do to prepare. So I've already kind of, spoiler alert, given you this. Will the Missouri Supreme Court decide to throw out a law that was overwhelmingly approved by the voters? That's the big question, and we have to say it's too soon to tell. Too soon to tell. I would predict and say it is unlikely. It's unprecedented. There's only one case in Missouri history that has overturned the voter approval, so just keep that in mind. Should you stop your preparations for the upcoming deadline? The answer is overwhelmingly no. All right. We're going to get through the easy stuff first. Minimum wage. So, minimum wage, the minimum wage portion of Proposition A, and I'll just backtrack for just a second. One of the challenges to Proposition A that was filed with the Missouri Supreme Court is that there's a constitutional rule in Missouri that each ballot initiative has to take up one issue. And so one of the challenges is that Proposition A took up two issues, minimum wage and paid sick leave. So that's one of the challenges that they are presenting. Now the counter argument to that is, well, both of them have to do with pay, and they're trying to say both of them have to do with pay, ergo it is one issue. So we'll see what the Supreme Court says about that. But back to the minimum wage. So current federal minimum wage, $7.25. 2024 Missouri minimum wage was $12.30. And then on January 1st, minimum wage went up to $13.75. It will go up again January in 2026 to $15 an hour. And then it will continue based on the consumer price index thereafter. Okay? So if any of you have not checked your payroll as of today, February 4th, you're already not in compliance, okay? Not in compliance with the law. So making sure that your hourly employees are appropriately being compensated for minimum wage for all hours worked. I often get the question, well, federal minimum wage says one thing, state minimum wage says another. Can't I just pay them federal minimum wage? And the answer is no. The law requires that you pay them the higher of the two. If the state minimum wage is higher than federal, you have to pay them state, and vice versa. Federal's higher than state, then you have to pay them federal minimum wage. Okay? This is pretty straightforward. Any questions on minimum wage? Y'all are like, we got that before we even got here.
There was a question.
I'm just curious why Kansas is so far behind in comparison.
As far as minimum wage goes. So Kansas has operated on monitoring the federal rules and follows the federal rules. So historically, there have been arguments related to farm workers and similar types of industries, which is why they just have not caught up or exceeded the federal minimum wage. Yes?
Is there an exclusion for businesses with income below a certain level as far as the minimum wage requirement?
Not for the minimum wage, no. So minimum wage, if you are working any amount for any employer, if you are a non-exempt employee, you are required. There are three primary rules. You're required to be paid minimum wage for all hours worked. You are required to keep accurate records and contemporaneous time records, and you are also required to be paid minimum wage or overtime for any hour worked over 40 hours in a 7-day work week. Not 80 in a pay period. If your business is doing that, you are breaking the law. I get that a lot. I do a lot of work with the Department of Labor, the Missouri Department of Labor, and The unfortunate part about wage and hour laws is that you are either in compliance or you're not. There's no gray area. So I will also say another issue that I see, and as it relates to minimum wage and overtime, is that overtime is calculated based upon the employee's regular rate. It is not based upon the employee's hourly rate. Does anyone know the difference?
Can you say that again?
So overtime for non-exempt hourly employees is calculated based on time and a half the employee's regular rate, not the employee's hourly rate. So you cannot automatically just say the employee makes $10 an hour, which would be below minimum wage, but you cannot automatically just say time and a half the hourly rate. You have to include all compensation that the employee would have earned during that period. So if you have an employee that earns any bonuses, any incentive pay, spiffs, anything else that tacks on to their compensation, it gets added back in, divided by the number of hours worked for that week, and then that gets you the regular rate, and that is what you get time and a half.
Does that include health insurance?
Well, health insurance is a deduction.
No, if we paid 100% of their health insurance, is that a benefit hourly rate that?
Has absolutely nothing to do with their compensation. Yes?
About travel time.
So travel time, so it depends on what you're doing for travel time. So if you're talking about, I'm going from one job site or location to another, and you're working in between those. Travel time in that situation is compensable time under the wage and hour laws. Now, you can pay employees a lower or a different travel time rate than you pay for their regular hours. And I think you're in healthcare, maybe? Yeah, so it is not unusual to have a different rate for travel time versus actual work time. And so in that situation, you have to add it all together, divide by the number of hours worked for that particular week, which gets you the regular rate, which then gets you how you get to your overtime calculation. Y'all thought lawyers couldn't do math.
So you can technically pay them below the minimum wage for travel time as long as their average is above that minimum wage.
That is not correct.
What?
That is not correct.
Okay.
So for minimum wage so for a non-exempt employee, which means that one of the white collar exemptions or an industry specific exemption doesn't apply. For a non-exempt employee, they are required to be paid at least minimum wage or higher for all hours worked. Now you can pay someone $20 an hour to be a healthcare aide and then pay them $13.75, thank you, $13.75 for their travel time. That would be fine. But you can't go below $13.75. Yes.
You said, and you take that regular rate and divide it by the number of hours worked in a week?
Correct.
Including the overtime hours?
Correct.
How would you calculate that then?
So you take the number of hours, or you take their base rate, their hourly rate, time the number of hours that they worked in the week, and then you add in any additional compensation. So a bonus, an incentive pay, year-end, quarterly extra compensation, whatever you might be paying, a commission, whatever you might be paying folks in addition to that, you add it all together, divide it back by the number of hours in that week to get basically your regular rate for the hours in that week, which means it will change and go up and down.
So if it's like a quarterly incentive, you would take that amount of money divided by the hours worked in the quarter and add that to the hourly rate?
So this is we're going to get into the weeds and the calculation. And for those people that are math adverse, they just tuned us all out. But so there's a couple of there are a couple of calculations for that, which is if you are paying a quarterly or a compensation based on a period of time, that you can retroactively go backwards to see how many hours were worked and if you have to do any true ups for weeks in which overtime was paid, versus I'm paying this out in this week and I'm going to deem the incentive pay earned on the week that it's paid. If I deem it earned on the week that it's paid, then I only calculate based on that particular week. So that gets very complicated math, okay? If anyone wants to play math on the boards after this, we can do so, okay? Okay, so next steps just on the minimum wage. The January 1st deadline has already passed. Make sure that you have identified any positions that are impacted by the change. So I put up here dealership employees with sales, service, and parts. There are certain industries, I didn't hear any dealerships in here. Are there any dealerships in here? So there are certain industries, and car dealerships are a unique example that they have their own subset of wage and hour laws in which they have what are called partial exemptions. So there's separate calculation, but I won't bore you with that detail. So make sure that your payroll system has made the adjustment. Don't just rely upon your payroll processor to ensure that your state minimum wage requirements have been updated. It is on your responsibility, and it is your business that's on the line if that is not in compliance. You can't point the finger at the payroll provider because I can guarantee that your service contract with them says it's on you. So, and also confirm those overtime rate adjustments as we talked. Okay. Is everybody ready for this next step? This next phase? All right. What you see on the screen here, oh, and by the way, these are all AI generated images that I created. So I do some presentations on AI and its use, but thought that would be a nice little plug. You're going to see the term earned paid sick leave in quotation marks as it is here on the slide. Proposition A, that is the language that is used. So to shorten things, because it is called earned paid sick leave, I'm just going to call it paid sick leave. Okay? So are we all clear on that? All right. So here's the important dates that you need to know. The first date that needs to be in your calendar is April 15th. April 15th is when the written notice is required. Hold on that and I'll explain what that is. Also, April 15th is when you are required to post a new poster. More to come on that. May 1st is when the accrual of paid sick leave begins. Okay? And then after May 1st, you will be required to provide every new employee this single page notice within 14 days from the commencement of their employment. Okay. So, what I would recommend on that secondary notice or for future employees post May 1 is that you will add this notice requirement into your new hire pack and that you are getting confirmation, a sign off that the employee has received this single page notice. Now, I guarantee somebody in here is saying, we'll throw that in our employee handbook and get that in a sign off. You cannot do that. You cannot do that. Because Proposition A specifically indicates that the notice has to be provided on a single piece of paper, one pager, and the font has to be 14-point font. And here we go, I didn't write this, folks. So now I'm going to backtrack here and talk about these notices. Proposition A also says that the Missouri Department of Labor will be tasked with creating a single page notice and will also be tasked with creating a poster. Hold please. They go a step further and say, if the Missouri Department of Labor does not issue a poster by the deadline, you're not required to post it. Great, thank you for that. However, if the Missouri Department of Labor does not provide a notice, that does not absolve you from having to provide it. So come up with something to give your employees. So fun fact, I have created such a notice. So if you would like to have a copy of that, I'm happy to share it with you. that is in compliance. There's very specific requirements. It has to be on a single piece of paper. It has to provide very specific notices. It has to give the employees contact to the Missouri Department of Labor to report you if you don't comply with this law. There's a series of things that are required to be on it. But I do have that and happy to share it with those of you that are here today. Don't act so excited, folks. Don't act so excited. So now this is the next bullet points here are talking about the size of employers. The ballot language and some of the initiatives around the ballot, I believe, this is my personal opinion, I believe were misleading. Because a lot of employers are saying, I have less than 15, this isn't gonna apply to me. Because that's what some of the materials told voters, which was applies to businesses 15 or greater. Well, the reality is that it applies to all businesses if you employ 1 employee or 10 million. Applies to all of you. So the difference between those is that if you have 15 or more employees, then the use of the paid sick leave can be, not must be, can be capped at 56 hours per year. If you have less than 15 employees, then the use can be capped at 40 hours per year. And it's can, not must. But I will emphasize, there is no cap on accrual. Now, I do have a teenage son, and I know that no cap means other things. But I mean in the literal sense, no cap on accrual. So what does that mean? So what that means is your employees can earn, and I'll go into the accrual in a second, but that your employees can earn paid sick leave, and you can limit the amount that they can earn. But you cannot limit, that they can use, but you cannot limit their accrual throughout the year. And then we'll get into the carryover of that. So the next question is, well, what businesses does this apply to and what businesses does it not? Because we talked about size of employer. So the accrual applies to any individual performing work in the state of Missouri, even if you have no physical location in Missouri. So think about industries in which we're crossing state lines, or construction in which we've got job sites on the Kansas side of the state line, folks on the Missouri side of the state line. How do you differentiate? Well, it's similar to how we have to report and track sales tax or reporting income tax or wages, is we have to keep track of the hours worked in that state. So even if you have a business that has an employee that lives and works in another state and they come to Missouri to perform work, this law requires we accrue time for that Missouri work. All of your faces are very angry at me right now, and I did not write this, okay? Now, I will tell you, so the exclusions. This is just a summary of exclusions, and I know the lighting is kind of weird in here, but I tried to use the red to kind of pull out the primary, the buzzwords to that are excluded. So I will tell you that unless you are a golf caddy, a newsboy, a newspaper with circulation limits, you have a resident or a day camp, you're a foster parent, almost all businesses this applies to. Now there is the annual gross volume sales of less than 500,000, which could exclude your business from having to comply with this. But generally speaking, I mean, these are very specific and kind of odd exclusions, I think. So make sure that if you believe you fall into one of these categories and don't have to comply, that you have that run up the flagpole with your legal counsel to make sure that you don't inadvertently exclude yourself based on these kind of odd groups. Questions about this? And if it didn't get worse, now come the violations. So there is an anti-retaliation provision in Proposition A related to employees using or requesting paid sick leave. And what I have listed there is called no administrative remedies. So generally speaking, if you have an employee that wants to file a claim against your business for discrimination, retaliation, harassment, etc., for any protected characteristic, there is a requirement that the employee exhaust their administrative remedies before they can file a lawsuit against you. So they would have to file that with either the EEOC or the Missouri Commission on Human Rights. This anti-retaliation provision says they do not have to exhaust that administrative remedy. They can go straight to court and file suit against you. Okay? That is very different from the way normal anti-retaliation claims are processed. There are also private right of actions and willful violations, which has created Class C misdemeanor for failing to comply. That would include failing to produce or provide the posting or that single page notice that I mentioned earlier. The private right of actions, the types of things that are available for somebody to collect. Reinstatement. So if you fired somebody and they said that they were terminated because you retaliated against them for using paid sick leave, they could be reinstated. They could get back pay meaning any loss of wages that they may have accumulated from the date of your separation with them moving forward. The full amount of unpaid paid sick leave, actual damages, liquidated damages equal to twice the amount of any unpaid sick leave. And to top it all off, you can also accumulate daily fines of $500 per day per violation. So the reason I said on the previous slide, if you think this law, you may have an exclusion to this law, run that by counsel before you say, I'm not going to comply with it. Because take $500, let's take 2 months. Take $500 per violation per employee. So you take every employee, $500 every single day, and you can do the math. That will add up very quickly. If anyone wants to do that math, I'm happy to, get out a calculator. So, penalties are steep for non-compliance. And when are you offering massages?
Next week.
Next week, okay.
Rick, isn't there a bar in this place?
Yeah. No alcohol. We know this, Rick. We know this. So, the next question that I am commonly getting is that there's been buzz and all the business folks are saying, oh, there's a provision in the law that says if I have an existing PTO or vacation policy, I don't have to offer anything else. Well, that's not exactly true. And so I took a snip of Proposition A for you to see here. And so what it does tell us is that any employer with a paid leave policy, such as paid time off, et cetera, as long as the amount of time is sufficient for the accrual, and as long as it is used for the same purpose and the same conditions, then you are not required to provide more time. So let's unpack this for just a second. Who do your normal paid time off or vacation policies apply to? Your full-time employees, right? Yep. So would that comply with the earned paid sick leave? No, it will not, because all employees, regardless of their classification, seasonal workers, a high schooler that comes and works for you for over the summer, temporary staff, assuming that they're actually your staff and not through an agency, any of your part-time folks, all are entitled to accrual of paid sick leave under this new law. So that is one example of, and why I have up here, that your current PTO or vacation policy will not likely comply without some administrative overhauls. So such as, do you allow for carryover? Do you allow for accrual? What's the amount of time that you require an employee to use your vacation or sick leave policy? A lot of businesses say you have to use it in half-day increments or full-day increments. Under the new law, you cannot do that. So that's where you can keep the amount of time the same so long as it complies with the accrual requirements, which I'll get into in a second. It is not likely, as it stands now, going to comply with the under the same conditions provision of Proposition A. It just gets heavier and heavier, doesn't it? So here are some examples, and I rattled off a few things of why your PTO policy may not currently apply, or may not comply with the earned paid sick leave. So the eligibility, we already talked about that. All employees are eligible, full-time, part-time, every employee, regardless of their classification. And then there is the accrual. So the accrual is all employees accrue 1 hour of paid sick leave for every 30 hours worked, but there is no cap on the accrual. I've already said that. But you can limit use based on your business size. So that 56 hours of use or 40 hours depending on your size. The other criteria that a PTO policy often would not comply with is that as soon as an employee earns an hour, it is immediately available for them to use. So oftentimes vacation or PTO policies will say you may accumulate or accrue time, but you cannot take it until after you've been with us for 90 days or 6 months or whatever it might be. So that would be something that immediate use would be required to do that. There are a variety of reasons as to what an employee can use this earned paid sick leave for. So it is for their own medical or mental health, caring for a family member, and I underline the term family member because the law has a broader definition of family than some of the other leave laws that we have to comply with. But there is a broader definition of family, whether it is a public health emergency, school closures, and for domestic violence reasons. Now, we all are still recovering from January and school closures, for those of us that have children. The way that the earned paid sick leave would apply to school closures is only if it is for public health reasons, also known as COVID, right? So if it's just a snow day or something along those lines, the earned paid sick leave would not apply under that circumstance, okay? The other provision that is required is that the law actually says the leave must be provided upon the request of the employee. Must. Not a get your supervisor's approval before you schedule this day off. Now, this is an area in which there is some ambiguity because the law does say that you can have a written requirement as to how an employee needs to notify you of their need for use. It says you must provide it upon their request, and that it says you can't retaliate or take employment action against somebody for requesting this time. So the big question is, well, the law is kind of conflicting if you put all these pieces together, and it says, well, I can require that an employee must call in and must do these specific procedures, but if they don't, can I deny it? And I don't know the answer to that right now. Based upon the way the law is drafted currently, it appears as though you can't without facing retaliation types of claims. So this is something we're going to need some clarification on and to try to gain some control back in the business that our employees are not just running amok. There is a carryover requirement. So at the end of the benefit year, which benefit year can be calculated, this is the one thing they do give you control over. Benefit year can be calculated on however you would like. It can be calendar year, it can be employee anniversary date, it can be your fiscal year. You could pick May 1 to be the start of the year. It's totally up to you, but you just need to have the same set 12-month period for a benefit year. So once your benefit year ends, you are required to allow 80 hours of carryover. Now, this is kind of a head scratcher. So if you do the math, and an employee is working, they're earning 1 hour of sick leave for every 30 hours worked. Most 40-hour-a-week employees work 2,080 hours, right? 2,080 hours. So you divide that by 30, and that gets you 69 and some change. So we can just round up and say we can anticipate an employee to earn, a full-time employee, to earn approximately 70 hours per year in this accrued paid sick leave. Okay? So remember, you're going to accrue up to, we're going to assume 70 for just purposes of our easy math here. But you can limit them to only take 56 if you're over 15 employees. Now the question is, well, that doesn't make a whole lot of sense. Now does it? So remember that employees have immediate access to use. The intent of that is so that when your benefit year rolls over, they will already have time in the bank. Do we see how that kind of plays out? Okay. The next part is about how people are paid. So the law uses this same hourly rate. That's for hourly employees. But there are special rules if you have employees that work under commission, piece rate, gratuities. There's a whole subset if you have folks that are earning compensation in different ways. For salary employees, you have to look at the previous pay period for an hourly rate based on hours worked. Your faces all tell me you regret your choice of being here today. You said, I thought Lauren was going to be entertaining and fun, and here we are. And now you're stuck, and if you try to escape, you're going to have to walk right by me.
I don't understand what hourly rate we're referring to, because we're talking about them accruing sick leave.
So when I take 1 hour or 4 hours of paid sick leave, the way in which you have to compensate me is the same hourly rate that I normally earn. So I can't.
They take it.
Correct.
Got it.
So the payout of that.
Okay.
And so if I'm a salaried employee, then you take what was my previous pay period and calculate, because you have to allow a salaried employee to take it in 1 hour increments, which is also something we don't normally do. But we have to allow them to take it in 1 hour increments. And how do you compensate a salaried employee that is guaranteed a set amount of money for every 7-day work week? How do you calculate that? And that's what it's giving us guidance on. Yes?
The 30 hours worked, is that 30 hours in a pay period, or is it 30 and then?
That is a fantastic question. What do you think the answer is?
It's total of 30. Anytime they go over 30 in a year.
Anytime they accumulate 30 on a rolling period, they earn an hour. So what it does not say is if you work 30 hours in a pay period, if you work 30 hours in a work week, that you accumulate 1 hour. It is as soon as you hit 30, you get an hour. So think about employee, part-time, seasonal. I think about high school kids, because this became an issue talking about the swimming pool and lifeguards. And, they may work 15 hours a week. Well, it may take them 2-3 weeks in order to accumulate 30 hours, but it doesn't matter how long it takes. As soon as they accumulate 30 hours, they earn an hour of this leave. Yes?
So when they leave the company or I terminate them, do I have to pay out all their accrued sick leave?
You are jumping ahead. Why are you firing your people already? So, but I will go ahead and answer that since you asked it. But I'm going to have to skip a slide later because of you. There is no requirement that you pay out accrued sick leave upon termination. Okay? So if an employee separates for any reason, termination, involuntary termination, or voluntary separation, you're not required to pay out accrued leave. However, you knew a but was in there, didn't you? You sensed that. But if that employee leaves, regardless of the reason, and you rehire them within 9 months of their separation date, you are required to immediately reinstate their prior balance. I didn't write this. Go ahead, yeah.
If you have to pay it, whenever they ask for it, you have to pay it. So on their way out the door, can they say, I'm going to be sick all next week?
Well, so that's a similar issue that you run into when somebody provides voluntary notice, right? That they say, I'm going to I'm going to give you a solid and give you 3 weeks notice,
2 weeks' notice.
but I'm going to take 2 weeks of vacate.
Leave accrued, so today's my last day.
Yeah. So in that circumstance, because I'm a good lawyer, I would say you document the hell out of that they said I quit today and I'm just going to anticipate being sick and you're not entitled to any compensation for that. Now, the smart employees, which I don't know where they work in here, but the smart employees will just say, oh, woe is me. I don't feel good for the next 2 weeks. And then, by the way, it doesn't do me any good to give you advance notice. And so now I quit on day whatever. Yeah. Don't tell your employees that. Yes.
There's an app for everything. Where's the app?
So that is a good question for your payroll provider. And so your payroll provider, if they are tracking time for you, do they have the ability to track this accrual for you as well? Now, there are other states in the country that have similar variations of paid sick leave accrual. So if it's a national payroll provider, they probably have something in the works as far as how to accrue it specifically for Missouri. But keep in mind, your payroll provider just provides you the service. It is your responsibility to make sure that it is accumulating correctly. Yes?
Speaking of firing people.
Am I fired officially right now?
For paid sick leave. So say if you happen to be out at a chamber meeting at, like, say, Summit Waves, and you see your employee who's supposed to be sick in the wave pool. Is that still because they're violating, because they're not really sick if they're out playing? Is that something that you can terminate an employee for catching them?
Misrepresenting the reason for their leave?
Yes.
So there is a provision that talks about a provision that talks about requesting the leave or fraudulently requesting the leave, because part of this also can be related to court appearances and domestic violence. So if I lie to my employer and say I have a court appearance for a domestic violence related reason for whatever, and then we later find out that that's false, well, I can terminate, I can take action for that. The reason I'm hem-hawing a little bit is that anytime we're talking about leave laws, all of the other laws stack on top with them. So like FMLA, VESA, Victims Economic Safety Security Act, which is related to domestic violence in the state of Missouri. There's also the ADA requirements. And so anytime that an employee, we have to be careful if those laws are happening at the same time, because if an employee says, I'm ill, or I'm recovering from something, and then you see on their social media that they're at Disney, you cannot terminate them for that, because there is not anything that says they're prohibited from traveling. So they may need to recover, may not be able to stand and make the widgets that you're having them make, but they can ride around in a little scooter at Disney, and we can't take action as an employer for that. Now, we can limit, they can't go work for someone else while they're on leave for us. We can fire them for that. So if they went to work at Disney, gone. Yes?
What falls under mental health?
Everything.
So it's like what Rick just said, like there's some ways when you approach them on that, because they just say, I was having a mental health day, and then get out of it.
Perhaps, yes. This is a pre-approved excusing. She's not running out, so.
I'm a life coach, this is just too much.
Yeah, she's like, I'm out. So the other things I need to talk about are tracking and record keeping. So the new law also requires that you keep track of paid sick leave requests for a 3-year period of time. So now we're going to talk about options here in a bit, but you have to be able to track and present records to the Missouri Department of Labor upon request if they are auditing your compliance with the law. So this comes into play as I've talked about your payroll providers. What is your HRIS system? If you have an HRIS system, how are employees requesting time off now? Are we tracking things like the reason for their leave? What have we done with PTO? We've said, you're adults, use it for whatever you want, don't tell me. If you have the time, you follow the protocol, you request the time, you can take it. I don't need to know. You can go to Summit Waves and float around if you want. You can be sick. You can do whatever you want. It does not matter. And now what this is doing, from my point of view, is kind of taking us backwards in time. That we're now going to have to ask employees, why are you using this time? And we're going to have to keep records of that. Mm-hmm.
So on that sense, we said we have PTO, and we're not planning to move away from PTO. The plan was to put this into, to ensure that they're accruing enough.
I'm going to get to this.
Okay. So I was gonna say, I was like,
I can't skip 2 slides, folks. Okay, the other bullet point that I need to make sure of is here, is that the only time you can request documentation for proof of an employee's leave is if they've been gone for 3 or more consecutive days. So if I have a doctor's appointment, I need to request a couple of hours. Even if your normal policy is you have to provide a doctor's note, you have to bring us a doctor's note to make that an excused absence, you can't under this. Only if they're gone for 3 consecutive days or more, regardless of the reason.
1099.
Not an employee. That's the easiest question of the day. Who else?
What about a commission worker? I've got 5 groomers that are all straight commission workers. Do they still accrue time?
Are you paying them W-2 wages or 1099?
W-2.
So you will have to track hours for them and the amount of time that they are working for you. So I advise a lot of businesses and a lot of industries. One that is really struggling with this because there is no exclusion under the Motor Carrier Act is truck drivers, over-the-road truck drivers. How are over-the-road truck drivers paid? Not by the minute or the hour, by the mile. And so how do we determine when you live in your vehicle, how do we determine what you're working and what you're not? So this is where I'm saying there's a lot of gaps and a lot of holes and a lot of industries that are not contemplated in the way the law is currently drafted.
So I have a remote employee that lives in Nebraska, works from her home in Nebraska. Does this apply to her? We're a Missouri employer, but she's doing her work up there. She comes in maybe once a month for a day.
I would say from a conservative approach, because you are a Missouri employer, I would conservatively say you should likely provide that to her. If you want to be more aggressive in the approach, so long as she's not stepping foot and performing work in the state of Missouri, I can make an argument that we don't have to compensate that time or to split it and say only the amount of time that she's physically in the state of Missouri. But I would ask the question of, is she performing work, creating sales for the benefit of the Missouri location? It gets a little tricky.
Yeah, and she's a part-time salaried employee, so it wouldn't apply, it would still apply to her because she's salaried. Yeah.
Wouldn't you also get into trouble because you'd be treating her differently than the other employees?
Not necessarily. I can make a good argument around this one.
There you go.
Okay, so let's dive a little bit deeper. So what's the paid sick leave notice requirement? We already talked about that. The single page notice cannot be in your employee handbook, has to be an individual piece of paper presented to employees. April 15th is the deadline. You have to provide that to all current employees. April 15th. Failure to do so will violate the law. So April 15th, put that on your calendar. The single notice to all current employees. After April 15th, anytime you hire a new employee, you are required to provide the notice again to the new hire, of course. My recommendation, add it into your new hire pack with your tax forms, your I-9 documentation, all of those things. It has not been released by the Department of Labor, but I got you on that one. How must the paid sick leave be accrued? Now, you can have, remember laws like this set a baseline. So an employee is entitled to accrual for 1 hour for 1 hour for every 30 hours worked. That does not mean that you are prohibited from providing an allotment. So an allotment is like a bucket of time. So at the beginning of my performance year or benefit year, whether that's calendar year, anniversary year, fiscal year, whatever you date you randomly pick. You can provide an allotment. Here's a bucket of time that you can use throughout the year. And so long as that allotment exceeds that 70-hour requirement of what we anticipate for a full-time employee, you're fine to do that. If you do an allotment and are not doing an accrual, you will be required to do what I'm using the term a true-up at the end of the year. Look at what that employee actually worked for you over that period of time and determine, would they have earned more than 70 hours? And are they entitled to any additional time in their bank? So, sometimes, especially seasonal businesses, we have spikes, where employees work 60 hours in one week, 50 hours the next, 30, how it goes. So make sure that you are doing that requirement. How is the paid sick leave accrued for salaried employees? So if you have a salary exempt employee, you should not be tracking their hours. I'm going to say that again. Why? Because you're going to violate the federal wage and hour laws and jeopardize your exemption. You all are like, those are a lot of wage and hour words. So the Proposition A does specifically say, if you have a salary exempt employee, meaning they are exempt from overtime, the presumption is that the person works 40 hours and you accumulate their paid sick leave based on that, because we do not track hours for them. That's the whole point of the exemption. As soon as you track hours for them, you're jeopardizing that exemption. Okay?
I have a quick question.
I have a long answer.
So my company works under a grant, and we have to report to the SBA the different programs under the grant that our employees work under. Like for myself, for example, if I teach a particular class, I have to report those hours. Like I spent 16 hours this week working on Boost to Business, and then the rest of the hours worked, I have to report those down. Is that in violation of what you just said? Because we are paid as exempt salary.
No, so there are a lot of businesses, so take a lawyer, for example.
Yeah.
I track my hour in the 10th of an hour. So in the 10th of an hour, and because I bill my time, not to you all, you get a free hour, but because I bill my time by the hour. And so for business purposes, I'm still salary exempt, or meet the learned professional exemption. But same thing goes with, like, think of a construction worker, like a superintendent that is managing multiple jobs, that they have to allocate their time to multiple jobs. Under those business purposes, that's acceptable. For just your, salary employee sitting in an office, not doing any of those things, we might have a problem.
Okay.
Clarification though, nonprofits, are they exempt from this or not? Just for profit or nonprofit?
There is not a nonprofit exemption. I've already talked to Matt about this.
I was like, he's a nonprofit too, so.
Yeah.
But
Yeah. So I've already talked about what's a benefit year, how you can calculate that. That is set by you as a business, so you can make that determination. I will say I would encourage you for this year, because this is the issue that's going to come up. The accrual goes into effect May 1 as we sit here today, assuming that you don't get a legal alert from me telling you otherwise. The accrual begins May 1. If you are a business that's doing an allotment, and you gave an allotment based on calendar year, and that was January 1, and you have an employee that has used all of their time by May 1, you are likely going to have to provide them additional time because the accrual doesn't start until May. So keep that in mind. I would encourage you to evaluate maybe a temporary 1-year situation for 2025 because you'll have this partial year circumstance in which you have 7 months, 7 months, right? Yeah, 7 months of accrual instead of a full 12 months, okay? Can I pay an employee for accrued but unused paid sick leave in lieu of the 80-hour carryover? And the answer to that is yes, but. So if you have an employee that reaches their end of their benefit year and you would like to say, I don't want to mess with that carryover nonsense, then you can pay them out. A lot of businesses do that for PTO now. Pay them out instead of rolling it into the next year. But if you do that, you are required to front load the entire anticipated bank in the next year. So let me walk through that example. You do, for 2025, you say, we're going to do an actual accrual for all of your hours worked, but I'm going to pay you December 31st, because I do calendar year. I'm going to pay you December 31st for the 12 hours you didn't use, okay? You will now be required to front load my paid sick leave for a minimum of 70 hours on January 1. There is a misconception out there, and I have heard this. That does not work in reverse. Hear me out. If you decide to do an allotment, meaning on January 1, we'll just use calendar year for ease of example. If you decide to do an allotment on January 1, you are not required to pay out. Okay, you can either do a payout or do a rollover. Do we see the difference? You're only required to do an allotment if you do a payout. But you're not required to do a payout if you do an allotment. Do we see the difference there?
Yeah.
Okay.
So you said you didn't write this? Who wrote this? Attorney to make more money for other attorneys?
You know what? It is job security, friends. Job security. We got each other's back. How long must I keep the PSL records? I've already told you that is a 3-year requirement. Oh, you forgot about VESA and FMLA. How does this work? So as I said before, VESA is the Victims Economic Safety and Security Act, which provides time off for domestic violence in the state of Missouri. And it is unpaid time for VESA, depending on your business size. FMLA is also unpaid time. So if you have a policy now, or you're going to create a paid sick leave policy, standalone policy, you need to make sure that the policy says these don't tack on to the end of one another, they run concurrent. So you do not get extra FMLA time, you don't get extra 70 hours on top of your 12 weeks of FMLA if FMLA applies to your business. So make sure that you have that clearly identified in your policy that they run concurrent, not stack on the end of one another, okay? Can I set requirements for how an employee must request paid sick leave? The law says that if you are going to put requirements in place, it has to be in writing and provided to your employees. Now the question becomes, can I deny it? What if I have 10 employees and 4 of them are already scheduled off work because of whatever reason, and I've got one person that's saying, I need to use paid sick leave, can I tell them no? And the current law says no. And the reality of the circumstance is none of us can force our employees to come to work as it is, right? I mean, what are we going to do? Drive over to their house and it's like, get in the car, we're going to work. I don't advise that. As a defense lawyer, don't do that. But we can't require them to come to work anyway. But what you can do is to make it clear in your policies that we need to know, are you using this time or requesting this time for vacay, or are you using it for a qualifying reason for paid sick leave? Because if they're saying, if you have a policy that's like a combined PTO or vacation policy, and they've designated, I'm going to go to Disney or, an island somewhere, you can say, sorry, we don't have the staffing to cover that. Can you schedule it on another day? But if they tell you, I'm going to be sick on this days, or I'm going to have a surgery or something like that, you're not going to be able to limit that scheduling requirement. Okay. I've already talked about what happens to the unused upon separation, and I'm going to wrap up here because this has been a lot of information. But what do you need to do? These are the things that you need to go back and evaluate for your business, what fits right for you. Are you going to add more paid time off or not? Meaning, I already have a robust PTO policy, or vacation, or sick leave, or whatever you already are offering. What am I going to do? Am I going to add on this paid sick leave as a separate standalone policy? Or am I going to try to morph my existing policies to fit with this law? Okay? The other, are you going to modify your existing policies? I've had some clients, and I will tell you I've drafted hundreds of policies for this since November, but I've had some clients that have said, we're just going to revert backwards to having a separate vacation policy and a separate sick leave policy, and keep the two buckets different so that I can administer them differently. But keep in mind, how is that going to appear to your employees? Depending on how robust your current policy is, if I carve out 70 hours of what I am offering for vacation and put that into a separate bucket and say your vacation is now only this small amount, maybe you only offered 80 hours. Now I'm going to only offer you 10 hours of vacation or PTO, and then the rest is designated as paid sick leave. Those are things you have to evaluate. What's that going to look like to my employees? One thing that I have been doing more frequently is creating a separate policy for part-time and seasonal employees. So a lot of businesses are taking the approach, let's retrofit our current policy to have the least amount of change for our employees, because that's easiest for employees to not freak out. Let's retrofit that for our full-time employees so that their time off period is not changed. Okay? They're still entitled to the same amount that they've previously earned. We just administer it differently. But creating a separate policy for part-time or seasonal employees that is the bare minimum that complies with the paid sick leave law, so that you have two different policies. Okay? That's what I've seen a lot of businesses do. Don't forget to consider those policy rollout communications and a plan with your employees. Has anyone's employee asked them yet about what we're going to do about this? Some have? Okay. And did you say, I don't know, it's a long time to me. I got a long time to figure this out. So 60% of Missouri voters voted yes on this, okay? So they're aware. You are going to have issues with employees when you make that determination, and because they're going to believe they're entitled to more. They're going to believe that they're entitled to their PTO and entitled to you tacking on this 70 hours of time. You now know, because you've sat here painfully, hearing all of these things, that you don't have to provide more time. You just have to modify your current policies. So how will you communicate that in a way that keeps employee morale up? Yes?
So can you look at all, because I have, I guess, holidays that I just automatically put in a holiday bucket, and then PTO, can you relook at your holiday offering?
Those are all fringe benefits. You can take them, give them, do what you want with them. And that is the reason why Missouri businesses are struggling with this, is because this is the first law that has tampered into the business's ability and authority to designate these types of leaves. We've always had the ability as businesses in Missouri to say, I'm going to offer fringe benefits that I choose to offer that fit for my business, what I can afford to offer, et cetera. And now we're being forced to, so we have to look at, from a financial perspective, where do we allocate this from?
So if I'm doing 7 holidays a year and PTO separately, we can decide we're going to 6 holidays a year, or whatever we want to do.
Yeah? I would just say, how did all of that sound to you? And how will your employees react to that? Are they going to say, pound sand, I'll go next door? Mm-hmm. Yeah. So just think through some of those things as you're making those decisions of, your demographics, your workforce, how are they going to react to that? So there's a lot of variations. I will say I have put together a paid sick leave policy pack. It is a 15-page document in which has a set of FAQs, the sample notice requirement, and then also 5 different variations of policies. Because of the amount of time that this has taken me to put together, I'm charging a flat fee of $350. That is far less than my hourly rate. So if it is something that you're interested in, it is a good resource so that you can kind of do a self-help and you can have a policy that's in compliance. Okay? I am willing to provide folks the sample notice. So for those of you that were attending today, I will provide that to you, which is also included in the pack. So takeaways, make sure you're calendaring those deadlines, and that you're evaluating your policies, you have a communication plan with your employees, and you do not want to get caught in one of those costly traps that we discussed. I know that was heavy and a lot. What other questions? Thank you, thank you, thank you. For those of you that will be at the gala this weekend, we can drink on it. So,
Here, here, dilly, dilly.
here, here.
Two related questions. One, the $500,000 small business threshold, if you will, that does not apply to minimum wage?
No.
It just applies to the...
Paid sick leave accrual. And whether or not your business is excluded from the paid sick leave accrual requirement.
And then on the paid sick leave accrual, I got two businesses. I've got a Liberty Tax Service over here that does $400,000 a year, and I've got a CPA practice over here that does $101,000 a year. Are they going to aggregate those since it's common ownership?
Depends on how the structure is set up. I'm going to assume that you had a good lawyer set those up so there was a clear distinction between those two businesses so we don't have to add them together.
You know, if you've got, I mean, for tax purposes, well, 100% ownership, common ownership, both entities.
I would say when we evaluate situations like that, besides the ownership arrangement, is there any sharing of labor between the businesses or sharing of, I'm going to send one accountant to work at one to work at another? If that's the case, it is going to be combined together. So lots of variations with that. Yep.
Piggybacking on the $500,000 requirement, is that Missouri revenue only?
I do not know the answer to that off of the top of my head, but shoot me an email and I will give you an answer. My email address is right there. Yes.
So we have PTO, and let's say the employees have three weeks, pretty common. And I've got one employee that is sick 2 weeks of the year, and I've got another employee that's sick maybe one day. They just never are sick. So to comply with this, because the one employee only took 1 day of sick, basically, do we still have to have the sick accrual that goes beyond their 3 weeks and set up the PTO?
So in your situation, this would be an example in which you are not required to provide more time because you are already providing more than 70 hours accrual throughout the year. What you have to be careful of, and this is where if you modify an existing policy, you have to ensure that the language has information in there that says you can use this for qualifying reasons for Missouri paid sick leave requirements, for vacation, for personal time, for whatever you want to use it for, you get to designate. And we as the employer reserve the right to ask you for your request reason. Not asking for documentation, because that's going to run afoul of the paid sick leave law, but I can ask you for a reason. I envision HRIS systems that I see put in a PTO request that says what for, drop-down menu, FMLA, vacation, PTO, you know, something along those lines. There should be an option for sick or Missouri paid sick leave compliant reasons or something like that, that they can designate. So the issue that you have with, so kind of the trade-off, I will say, if you decide to use a combined vacation and sick leave policy, is that you cannot use the limits. So remember that you can limit the amount of time that an employee can use the earned paid sick leave requirement. I'll let you go. It's fine. I do feel like I'm trapping everyone in here. I think in law school they would call this that I am imprisoning you. But anyway, so the trade-off of that is you can't restrict, you're going to earn all of this time and you can only use 56 hours because they can use it for whatever they want, right? So that's kind of the trade-off if you're using an existing vacation or sick leave policy. Yes?
Can you go over really quick again what you said you would include in that packet for 350?
So there is an FAQ of the information that is in here. There's the one-page notice that is compliant with the Missouri paid sick leave law. and it is in 14-point font, don't forget that part. And then there are 5 samples of compliant policies. There are 2 samples of just a standalone earned paid sick leave policy, 2 different variations based on your business size, whether you do a carryover or a payout. I tried to make as much variety so you can kind of pick and choose. And then I have 3, I believe it's 3 variations of a vacation policy, a PTO policy, 2 different variations of a PTO policy on an accrual versus an allotment, so that you can see how all of it can work and kind of retrofit into your own policy what that would look like. Mm-hmm. Yes?
Can you cap the accrual amount?
No.
So in that instance where you have the employee that only took 1 hour out of what you drew throughout the year, say you can only carry over a max of 80 hours. You can't cap that accrual amount?
You cannot cap accrual, but you can cap carryover.
Okay. Okay. And how much can you cap carryover?
80. So there are a lot of businesses that have 200 hours of vacation. I'm still trying to get a job there, but anyway. And so you can say we're gonna, you can even have tiers to say the lowest level you're capped at carryover at 80 hours. At the higher levels, 200 people that have been there for a decade, you can carry over 150 hours. As long as you don't go below the baseline of what the law requires, you can keep that as same. Okay. Okay.
Give Lauren a round of applause.
I will stick around for a few minutes to answer questions and take this microphone off. So if you do have questions that you want to ask me privately, I'll stick around for a bit.